All right, good morning.
Good morning, and may it please the Court. Stephen Maidman for the defendant John-Claude Jules. I'd like to address the Miranda issue first, and then the ineffective assistance as counsel claim involving the suggestive identification issue second, and that's the order in which they're presented in my brief. The first issue involves whether the defendant knowingly and intelligently waived his Miranda rights. And the defendant's contention is that that it was impossible for the Commonwealth to prove beyond a reasonable doubt that the defendant waived his rights because there was no recording of the interrogation. The defendant was not fluent in English. He spoke Haitian Creole. There was a police interpreter who was unfamiliar with Miranda warnings, who the state trooper asked to Mirandize the defendant. She testified that she read it word for word. Then she said she didn't read it word for word. Then she said she adopted the Commonwealth, the prosecutor's question, did you give the substance? And then previously the judge was, the motion judge heard that at the grand jury she testified that he didn't sign the form because he didn't know what he was signing.
Well, can I just ask you, something
Sure.
threw me, a gender question just threw me. I thought that the interpreter's name was Pierre Saint Laurent.
No. No,
Okay.
it was a
Nicole something.
right.
Okay.
That's correct.
All right.
No, it was a woman. She was a civilian employee of the Brockton Police Department who was fluent in Haitian Creole,
Okay.
and but she was unfamiliar with Miranda warnings. And there's a fair number of cases throughout the country, especially in jurisdictions where they which predated Giambattista, where they tape recorded Miranda warnings. And one of the things that you see in the case law is you find out that many times where you're dealing with non-English defendants, the translations of rights are not entirely the same as normal English diction, normal English syntax. And sometimes the translations are completely wrong. And in this particular case, there was, this is before, the interrogation was before Giambattista. The trial occurred after Giambattista. And there was no tape recording at all. And that was something that the state trooper could have done. What I would ask this court to consider is whether the police had a special duty, let's say, that's a fair characterization, a special duty with non-English speaking defendants where there are translators to have a tape recording. Because unless you know what the interpreter said to the defendant and what the defendant said back to the interpreter, you'll never know beyond a reasonable doubt what happened. In this particular case, the motion judge, he ruled there was custody, and then he went on to say that the defendant, he understood his rights. And he also wrote that the refusal to sign the Miranda form, which was in English, wasn't even in Haitian Creole or wasn't in the language of the defendant, that showed lucid consideration of his options. I'm not sure I'd ever characterize as lucid consideration of his options. But nonetheless, he ruled that the statement was admissible.
Now, let me just make sure I understand. The judge made various findings, including that she essentially was asked to read the Miranda warnings word for word, and that he appeared to understand them, and that he appeared to be somewhat educated, at least in his approach and answers. Clearly erroneous, or are you saying, no, they're not clearly erroneous, but we should still establish this separate rule?
I have to prove beyond a reasonable doubt.
But
not clearly erroneous
no,
standard.
the question is whether his findings.
Oh, his findings. Well, this court will examine those findings and apply the law to them. And
but the law at the time, this was 2003. This was
Yes.
even pre-Giambattista, so there wasn't even the guidance from this court, at least the precise guidance, to say you need to tape record. So you're saying, even though this was pre-Giambattista, we should not only say that it would be a good idea to do it or a very good idea when you have a translation, but that the failure to do so per se means that it cannot be found to have been knowing and voluntary?
Well, if it had been done, if the interpreter had been a court interpreter, okay, Miranda's been litigated now for 45 years.
Right, but, remember,
1966
but
now.
what she's being, it's one thing if you were to say they misunderstood something that he said, but she was a fluent
Yes.
Creole and English speaker, and the part that you say matters most is whether she could read and translate the Miranda form, which...
It's unclear. I mean, again, given the totality, I'll use totality of the circumstances, given the fact that you have a guy who doesn't speak English, at least the police certainly thought he didn't speak English, and you've got a refusal to sign a Miranda form that's in English. If the standard is proof beyond a reasonable doubt, the highest standard in American law, I would suggest this doesn't cut it.
Are you saying, and Justice Gant's question, are you saying that as a matter of law, or that we should say, under our superintendent's power, that it is automatically error if you've got a non-English speaker who's speaking to the police with an uncertified interpreter, that you need to record it?
I don't know.
You cannot prove voluntariness?
I do not know if I go as far as say it's per se. We got policies. Are we going to put a court-certified interpreter in every police station? That probably is not going to happen. On the other hand, where you don't have this issue probably would not happen today, because you do have in the most cases.
We're back in 2003, so we're trying to figure out what
Well,
it is that you
this-
think should have happened. Or not what should have happened. I know what you think should have happened. What you're saying the rule is going forward.
Well, I think the rule should be if you have a non-English speaking defendant and someone's interpreting Miranda warnings, you need the translation. I think, again, I hate to use the word.
The form to be in, is that what you're saying?
No, but that's not a bad idea either. Matter of fact, I think the case law shows that in most police stations where there are large populations of whether it be, Spanish, Laotian, Cambodian, whatever, where some of these cases come from, they do have those forms. But here you didn't have the form, and you didn't have the translation. You didn't have, for example, when in this particular situation, the interpreter did not testify. I read each right, and then I asked him whether he understood it, which typically is what I'm used to seeing in transcripts. I'm sure you are too. That didn't happen here either. But whether you want to make a per se rule that no translation, therefore we must throw it out, I'm not sure I'd go that far. But on the other hand, under the circumstances of this case, I just don't think that the Commonwealth has met its burden of proof. And unless you have any further questions, I'll move on to the second issue. Second issue involves the ineffective assistance of the counsel. Now, the actual photograph, I couldn't find it in the record, so I went and put it into the record. And it's on page A18 of my, R18 of my brief. And for those of you who haven't seen it, this is a picture. It's the front page of the Boston Herald. And it's the defendant's picture in handcuffs under the headline, "A Brutal and Horrific Murder." And the defendant's contention is that, and by the way, this eyewitness, was the only witness that directly connected the defendant to the crime scene, or at least one of the secondary crime scene, the car. And not to move to suppress it, and not to move to have a hearing, and not to find out what this lady knew or didn't know in terms of her identification. Defense contention is that was subpar constitutional performance under the first prong of Safarian and Strickland. In the motion for new trial, the motion judge, Judge Tin, he took the position that since he relied on a line of cases that the main one being the Massey Jones, Commonwealth versus Jones, Massey Jones case. And he took the position that since there was no state action, and the defendant concedes there's no state action, the Commonwealth does not control the Boston Herald. There was no state action in this case. That therefore it's not a problem. And there is some support in the line of cases that talk about casual encounters in neutral surroundings, and in the media being exempt from this line of cases that talk about common law principle of fairness banning the suggestive identification. I would suggest that in Massey Jones, the eyewitness worked in a hotel or a motel and saw the defendant there. Then she goes to court on 2 occasions for pretrial conferences, and she sees the defendants handcuffed to other defendants, and that was held to be a suggestive identification, and but not engineered by the Commonwealth, and common law principles of fairness dictated that identification be suppressed unless, and that subsequent identifications would have to meet the test of showing by clear and convincing evidence that she had an independent source of identification. I would argue, and that there is essentially no difference between seeing, as in Massey Jones' case, a defendant shackled to another defendant. There's no difference in terms of suggestiveness between that and what happened in this case. If anything, it would seem to me that the amount of suggestiveness was comparable, and perhaps even more so. I mean, you look at the Herald picture. He's under a headline, brutal, horrific murder. He's in handcuffs. It's certainly highly suggestive. And how can you distinguish that?
Is there a distinction in that case she would have understood that he was there on her case, or is that not a fair reading of Commonwealth versus Jones?
That was the fair reading is that that's where she got the identification from. Right.
But I mean, would it be a fair inference for her that when he was in court in shackles, he was there because of the case that she was also in court for?
Well, they were co-defendants, and yes, I think so. I think that's what the case.
But here, assuming we credit her testimony, I guess at trial, where she said she didn't even read what it said. She had, I guess, her husband had said to her, "Have you seen the Herald?" And she looks at the Herald and she sees that front page and she says, "That's him." She wouldn't necessarily be certain that that they were reporting the particular murder that she was aware of. Is there any distinction there, or is that one without a difference?
I don't think there's any distinction there. I mean, yes, I guess the court could credit her the fact that she didn't read it. I find that hard to believe, but nonetheless, if that was the testimony. But I think it's highly suggestive, connects him to a murder, and then if you turn to the second, and that's part of the problem. There was no suppression hearing, so the lawyer couldn't go through step by step by step, saying, "Well, did you see the first page? Did you read that? Did you read the text? Did you read the article? And by the way, the night before the motion hearing, did you go back and look at the picture?" Okay. We don't know any of those things, and to not do those things certainly raises questions. And the defendant's lawyer in his affidavit in the motion hearing acknowledged it.
Do you have to establish that she would have likely prevailed, or the lawyer would likely have prevailed?
Reasonable, federal law, and I assume Massachusetts is consistent, is that there was a reasonable possibility of prevailing, and I would suggest that there is some reasonable possibility that her identification would have been thrown out, especially the trial identification. She testified that that's the man, having seen him for 10 seconds 3.5 years ago, assuming she didn't look at the Boston Herald in between. And that's pretty far out.
Now, what do we do? The opinion by Judge Chin makes reference to Jones, but then when he makes his findings essentially says you would not prevail because the record establishes that Ginsburg's initial exposure to the photograph was through the media and does not support any claim that Boston Herald published the photograph of Jules as a result of any conduct on the part of the police. So that's not a Jones analysis. It's not a due process analysis. It's a federal constitutional analysis that there was no misconduct by the police. But what do we do here where the judge references Jones but actually doesn't address the Jones issue?
I could remand it for a new trial and find out. That's one thing you could do. But I think that Judge Chin did not. I think he saw the line in that case and the other cases, the Horton case that's cited by the Commonwealth, in Bly case, where the neutral casual encounters in neutral surroundings and the media do not come under the common law principles of fairness. And I think it has to come under common law principles of fairness because you can't distinguish between this particular situation and walking to any courthouse in Massachusetts and seeing people handcuffed to, and basing your identification based on that. I mean, if the Boston Herald is suggestive, then I don't think there's any principled distinction between this case and the Massai Jones case.
Now, here, of course, he caught her eye. I mean, she does this route early in the morning.
Right.
She generally sees nobody there.
Right.
And there she sees this fellow who is walking or running somewhat briskly, and she remembered this. So this is not just a casual glance. This is somebody who says, this is funny, this is unusual. Does that not matter here?
Again, this is the whole thing, the whole debate about eyewitness identification. You're right. She saw a guy.
And by the way,
this guy?
Is she white, by the way?
It's not in the record.
The record doesn't reflect her
Record.
race?
I can't argue it's a cross-racial problem. I can speculate, but beyond that, it's the correct answer. I mean, I have my own view in this. I'm sure you do too. It's not in the record. But nonetheless, what is startling is that 3.5 years later, based on her grand jury
Wait,
testimony.
3.5 years later. No, wait. She saw this photo just a couple of days afterwards, right?
Right, but the courtroom identification.
Yeah, I understand. But so this is the person, all right? Now, did she report that to the police?
She called
Yes.
the police.
Yeah. Okay. So she's made an identification based on her memory from a day or two before and seeing this photo. So isn't that what ordinarily happens? Then there's this passage of 3 or 4 years before there's a trial. How could you remember who you identified, who you saw back then?
That's right. How could?
Well, that's every case. How could you possibly remember?
Well, if
4 years ago.
If the Commonwealth is going to introduce her testimony in a courtroom saying that's the man, she better be pretty sure that's the man. It's one thing to say, well, I identified him based on a picture in the Herald at the time, and I called the police. Prior identification, but she did it in court in front of a jury.
But what you're suggesting is there should then have been a lineup, and that would have made a difference.
It should have been something else. I mean, I just to allow it in the courtroom based on 10 seconds 3.5 years ago for her to again, the real thing turns on is
But she's not being called in cold after 3.5 years and asked, "Do you remember who you saw 3.5 years ago one morning early?"
That is what she was asked.
No, she's made an identification 2 days after the fact. 2 days after the fact, which is typical.
Based on a highly suggestive display.
But of course, if she did not make the in-court identification, she may be allowed to describe in more detail her out-of-court identification, which would probably not be a happy result for the defendant because it may get into evidence the fact that she saw him on the cover of the Boston Herald in handcuffs. So this may have been a less costly alternative for the defendant than what he would have gotten if the in-court ID had been barred.
Well, I see my time is up, so I thank you and rest on my brief.
Thank you, counsel.
Thank you. Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, on the Miranda issue, the defense...
Before you get there, let's talk about the Ginsburg ID. What do we do with the fact that Judge Chin appears to rest his finding on the absence of government misconduct, which there's no dispute there was not, but the Jones case doesn't rest on government misconduct. There was no finding there of government misconduct. So what do we do? Because then we don't really have a finding in terms of the common law due process issue raised in Jones.
Your Honor, the Commonwealth's memorandum in opposition to the motion for new trial laid out all the case law that's laid out in my brief. The Bly, Horton, Jones itself, I believe Sylvia at that time, that indicates that the case law was quite clear that under the Jones analysis, mere exposure to a picture of a defendant in the media, in most of those cases, they're pictures of a defendant from his indictment, from his charging, that's not sufficiently suggestive under the Jones analysis.
I understand that, but you also understand that Judge Chin didn't say that.
It's implicit, I'm saying, Your Honor, because the argument was in front of him, the case law was clear, and Jones itself says that media exposure is not enough.
Okay, so you're saying that the finding that you describe is implicit in what he wrote, even though he appears to be focusing on the absence of government misconduct here.
Right, Your Honor, because we do generally have a presumption of propriety on a judge's decision-making. The argument was fully addressed and fully presented to him. He's got to be understood to have understood that argument. The law was, in fact, crystal clear, as it remains crystal clear, that under the Jones analysis, the kind of exposure that the defendant has alleged is insufficient.
Don't you have to, I don't know this, but isn't it a sort of depends on the circumstances? I mean, it isn't.
That hasn't been the analysis of the court, Your Honor, and that would be a brand new introduction here. The analysis of the court, which I suggest, Your Honor, has been consistently with pictures in the paper showing the defendant as the person charged with the crime, and the court has consistently said that has not been sufficient. There is nothing in this case that would distinguish that, Your Honor. In fact, there's less here than there was in many other cases that found insufficient suggestiveness under the common law Jones analysis.
Now, your brother says, let's look at Jones, and this is not materially different from Jones. Is it materially different from Jones?
Yes, Your Honor. Jones was in court where the defendant was shackled to joint venturers that the witness identified and recognized, and the association with the joint venturers was there. It was long-term exposure to them during ongoing court proceedings. And was quite significantly different.
And what had the witness said about Jones or that person before she saw him in the courtroom? Do you remember?
Your Honor, I want to say that she had failed to identify him in a photo array, but I'm not sure. You know, I don't remember in sufficient details of that, Your Honor. In this case, the evidence was that the witness paid particular attention to this person because she'd never seen anybody on the street at that time in the morning. She'd noted it particularly before she had any idea that there was a crime involved. She talked to her husband. She said, you know, it was odd. I saw this gentleman out on the road today. She described what he was wearing, consistent with the other descriptions, clothing that had to have been different than the picture that there would be in the held picture because the evidence was consistent that he changed his clothing by the time he was arrested. She described him, she noted him in particular, and she said that she had no memory of having paid any attention to any of the writing in the paper and just seen the photograph. Your Honor, this is a not a particularly suggestive ID at all. It's a simple exposure to a media picture and is no more and far less than many of the cases as I've outlined in my brief. To suggest here, well, Your Honor, I think you effectively have to overrule a consistent line of cases that say that this kind of media exposure is just insufficient as a matter of law.
How was this handled at trial? How was the cross-examination of this witness handled at trial?
It was challenged at trial. That's where we know. That it's from the trial evidence that we know that she looked at the picture in particular and didn't pay any particular attention to the writing.
So this was fully vetted on it.
In front of the jury, yes, Your Honor.
Was the photograph introduced? Or at least, was it shown at trial?
To the jury, Your Honor, I don't remember. I don't believe so, but I don't remember, Your Honor. I believe it was shown to the witness, but I don't. If there's nothing else on that, then I just mentioned, sort of as an introduction to the first argument, that the defense here has said that the only witness that placed the defendant at the scene of where the car was abandoned with the victim's body in it was this witness, and that's simply not true because the defendant himself said that he was driving into those towns with her in the car on the way to the hospital, and he decided that it might look bad for him, and he left her in the car on the side of the road. So it's by no means the only evidence that ties him to that car in that location, Your Honor. In terms of the Miranda issue, the defense is, in fact, effectively arguing that at least where a translator involved, there should be a per se requirement of a recording, and all subsequent statements by a defendant should be suppressed because of the lack of recording. This court has consistently refused to go that far because of a lack of recording, and instead, in DGM Petitioner, in particular in Commonwealth versus Andone, which is at 428 Mass 496, where the issue did involve a non-certified, non-independent interpreter of Miranda warnings, that it's not appropriate to simply suppress everything because there's not a recording, but rather it simply is a factor that the fact finder could take into consideration into the credibility of the waiver, of the evidence of the waiver. That is the way it was addressed here. That's the way it was approached. That's and this case has been entirely consistent with the full line of cases on that line. There's no principal difference, but just because a translator involved here to say that a recording is the only possible way to say what actually happened. What we have here is a witness, the translator, who said that she translated the form that had the Miranda rights. She translated it word for word.
But now, Mr. Maidman says, yes, she did say that, but she also said, well, maybe not word for word, but there was a bunch of different statements about what she actually did.
You can. Well, first of all, the judge credited the statement that she accurately translated it. You can look at the statements, of course, on your own. What she said at one point is word for word, and then she said, well, not word for word, more line by line to communicate the substance, which I at least read as saying, I didn't do you may, not literally word for word, but more sentence by sentence. I mean, that's the way I understand that. The judge credited as giving an accurate recitation of the Miranda warnings. Your Honor, as a matter of principle, then that leaves this case essentially no different than any other case where an officer comes in and say, I read the card to the defendant. And you could say, as the defense might say, how would we know that's possibly true? Well, we know it's true because we credit the officer's testimony, just like the vast majority of factual questions that are presented to the court, in fact, throughout most of every trial in the Commonwealth. Your
Well,
Honor.
except one of the problems with interpreting English to some other language and some other language to English is entirely a different question than reading English and then speaking English off of what was just read, because it is word for word when you go English to English, English word to English, English speaking. But that's not necessarily true when you go from English word to foreign speaking.
Your Honor, she did say that she translated word for word. He appeared to understand everything she said, and he had no questions about it, and there appeared to be no problem with it. This is beyond that, Your Honor.
Well, isn't there also
Somewhat handicapped here because, in fact, in the trial court, there was no challenge to the translation whatsoever, Your Honor. What happened in the trial court was that he suggested that the lack of the signing of the English form indicated overall that the statement was not knowing and voluntary, Your Honor. There was no one asked, as happened in Colin Cruz, that's cited in my brief, no one asked exactly how she translated the form. No one tried to challenge any wording of the way she did that. The defendant has never said in his affidavits or anywhere else that somehow he didn't understand the words she was speaking to him. That simply, there's been no challenge here. So we're somewhat handicapped here because of the belated raising of the issue. There is simply no evidence here that would support an idea that, in fact, the Miranda warnings were translated inappropriately. There's also no evidence here that, in fact, there was any kind of cultural problem in the defendant's ability to understand the Miranda warnings. None of that is just simply its entire speculation. The defendant in this case, there is also no showing of any kind of reluctance on the victim's part the defendant's part to speak. In fact, it's just the opposite. He was saying, "I have nothing to hide. I want to speak."
how would somebody challenge something like this?
Your Honor, in Colin Cruz,
Would you have the actual interpreter come in and say it in the language, in the foreign language, and then have a certified court interpreter present, listening to what was being said in the foreign language, and then translating that into English? Is that what would
Your
be
Honor,
done?
that's essentially what happened in the case of Colin Cruz, which is at 408 Mass 533. The translator was on the stand. The defendant asked her to specify exactly how she translated. He had an interpreter in the courtroom with him who was then able to testify as to he was a certified interpreter who apparently had familiarity with Miranda, and he was able to testify as to the accuracy of the translation in that case. So Colin Cruz is a case that came out in 1990, well before any of these incidents here. If the defendant had wanted to do that stuff, he certainly could have, but nothing like that was done. Your Honor, essentially here, the court cannot fairly say, no one can fairly say that the judge's findings that the Miranda warnings were accurately conveyed and that he understood them is clearly erroneous because it's based on direct testimony that that was what was done, Your Honor. It's supported by the evidence. At the most, the lack of recording should have been considered as a factor on the possibility that it's not sufficiently reliable. It was argued that way to the judge. It was considered that way. The judge found in a different direction. Your Honor, there is really no justification in this case to create a rule that would say that that now we're going to have a per se requirement. First, there's no indication that this is an ongoing problem. My brother suggested it. In his view, it probably wouldn't happen today, and I think that's accurate. The testimony at trial was that this happened before DG and Batista, and the policies of the state police involved here had changed, and now the preference was to record whatever possible. So there's no indication, there's no need for, there's no showing of any kind of ongoing problem that would need this court to go further than they have in DG and Batista and Ardon or McGowan, that they've refused to go further in the past and extend it here. It's just simply not justified in this case in particular, Your Honor. And if there's nothing else, I'd rest on the brief.
All right, thank you.